Hey guys, this is Tawhid Shakil. I am back with another video, and in this video we will discuss an important topic, Article 370 and Article 35A. So here are the 5 key points we are going to discuss in this video. Difference between Article 370 and Article 35A. Historical background of Article 370. Can Article 370 be amended under the provisions of the Constitution? The consequences of repeal. Article 370 of the Constitution of India is an article which grants special autonomous status to the state of Jammu and Kashmir. All the provisions of the Constitution which are applicable to other states are not applicable to Jammu and Kashmir. For example, till 1965, Jammu and Kashmir had a Sadr Riyasat for governor and prime minister in place of chief minister. So what's the difference between Article 370 and Article 35A? Well, both are the articles of the Constitution and both concern the state of Jammu and Kashmir, both of them being temporary provisions. The difference is with respect to their subject. Article 370 protects and grants special status to the sovereignty of the state, giving power to make a separate set of laws to be applied for its governance, incorporated in the Constitution of India. So, what are the provisions of Article 370? According to this article, except for defense, foreign affairs, finance, and communications, Parliament needs the state government's concurrence for applying all other laws. Thus, the state's residents live under a separate set of laws, including those related to citizenship, ownership of property, and fundamental rights as compared to other Indians. As a result of this provision, Indian citizens from other states cannot purchase land or property in Jammu and Kashmir. Secondly, under Article 370, the centre has no power to declare financial emergency under Article 360 in the state. It can declare emergency in the state only in case of war or external aggression. And Article 35A. Article 35A protects the rights of the people with respect to employment, property, and aids by the state government, not incorporated in the Constitution of India. Article 35A of the Indian Constitution is an article that empowers the Jammu and Kashmir State's legislature to define permanent residents of the state and provide special rights and privileges to those permanent residents. Article 35A of the Constitution is a derivative of Article 370, which allows the Jammu and Kashmir Assembly to define who is a permanent resident, who is eligible to vote and work for the state, who can own land and get admission in colleges. Article 35A is a set of laws. Those are discriminatory in nature and in conflict with Article 14, 15 and 16 of the Indian Constitution, which relate to equality of opportunity in matters of public employment and reservations. It also violates the fundamental rights under Article 19 of the Indian Constitution. Article 35A also gives rise to a situation wherein a person who migrated to POK at the time of partition and returned on valid documents is eligible to buy property in the state, while the Indian citizen cannot. So it is very clear that 35A gives special rights to permanent residents of state, while it empowers the state legislature to define permanent residents and then give them special treatment, privileges and rights. The special treatment is with respect to employment with the state government, acquisition of immovable property in the state, settlement in the state, or right to scholarships and such other forms of aid as the state government may provide. So, what is the historical background of Article 370? The provision was drafted in 1947 by Sheikh Abdullah, who had by then been appointed Prime Minister of Jammu and Kashmir by Maharaja Hari Singh and Jawaharlal Nehru. Out of the 562 princely states in India, Kashmir was among those that the British did not rule directly. The British government transferred the state forever to Maharaja Gulab Singh under the Treaty of Amritsar 1846 and fixed a nominal annual payment to protect his territories from external enemies. A key development in the history of Jammu and Kashmir in the 20th century is the crystallization of the popular opposition to the Maharaja's rule through the Jammu and Kashmir National Conference led by Sheikh Abdullah. With India's independence, Maharaja Hari Singh, the ruler of Kashmir in 1947, had three options: to remain independent, to merge with India, or to merge with Pakistan. Pressing the Maharaja, who initially wanted to remain independent, to accede to India, Prime Minister Jawaharlal Nehru is in one of his letters said, "It's the most vital importance that Kashmir should remain in the Indian Union. But, however much we may want this, it cannot be done ultimately except through the goodwill of the mass of population. Even if military forces held Kashmir for a while, a later consequence might be a strong reaction against this." In 1947, the countries of India and Pakistan came into existence. The partition decided the fate of millions, but people of Kashmir faced an uncertain future. Maharaja Hari Singh managed to keep the region independent for 2 months. He did this by signing a standstill agreement with Pakistan and sending a similar agreement to India, which favored continuing discussion. But that changed in October 1947. The tribesmen they were active without the support of Pakistan approval. The Maharaja sought military assistance from India. Pakistan immediately launched a guerrilla war to free the region, which had a majority of Muslims from India rule. The Maharaja, realizing his inability to protect his territory, requested the Indian government for help. The Indian government insisted that Kashmir accede to India before it would send its army. The Maharaja agreed to the same, and the Indian government and the Maharaja signed the accession treaty, the instrument. Thus, on October 26, 1947, Maharaja Hari Singh signed the instrument of accession. On October 27, 1947, Indian troops landed in Kashmir to fight the rebel forces and Pashtun tribesmen. This led to the first India-Pakistan war. During this war, India's then Prime Minister Jawaharlal Nehru promised a referendum. The fate of state of Jammu and Kashmir is ultimately to be decided by people. The pledge we have given not only to people of Kashmir but also to the world. We will not and cannot back out of it. A little over 2 months later, India referred the dispute to the United Nations. A resolution was passed on August 13, 1948, asking both nations to withdraw their forces. Once that happened, the referendum was to be held, allowing the people of Kashmir to decide their political future, but the troops were never withdrawn and referendum never happened. Importantly, Clause 5 of the instrument said that it could not be altered without the state's consent. Clause 7 specifically protected the state's right to ratify the application of any future constitution of India in its territory. It read, "Nothing in this instrument shall be deemed to commit me in any way to acceptance of any future constitution of India or fetter my discretion to enter into arrangements with the government of India under any such future constitution." The instrument did not result in the merger of Kashmir, governed by its own constitution of 1939, into India, and only created a temporary settlement under which India's government would look after the subjects of defense, foreign affairs, communication, while Kashmir would have its own constitution, flag, and prime minister. In a broadcast on November 2, 1947, Nehru spoke of a temporary nature of the instrument. Both the Kashmir government and the National Conference pressed up to accept this accession and to send troops by air, but made condition that the accession would have to be considered by the people of Kashmir later when the peace and order were established. Some of the other important events that influenced the drafting of Article 370 were the political turmoil in Jammu and Kashmir, the United Nations resolutions calling for plebiscite in the state on the issue of accession to India, the governments of both India and Pakistan establishing political control over the territories of Kashmir under their control, and the representatives of all the other states choosing in India's Constituent Assembly to not assert their right to separate constitutions. Jammu and Kashmir, unlike the other princely states, was not willing to accept the Constitution of India and was adamant on acting only on the basis of the terms of instrument, specifically Clause 7. Gopalaswamy Iyengar, a minister without portfolio in Nehru's government, moved the bill for Article 317 in India's Constituent Assembly. He made the following argument. Till India became a republic, the relationship of all states with the government of India was based on the instrument of accession. In the case of other Indian states, the instrument of accession will be, a thing of past in the new constitution. The states have been integrated with the federal republic in such a manner that they do not have to accede or execute a document of accession for becoming unity of republic. It would not be so in the case of Kashmir, since that particular state is not yet ripe for this kind of integration due to special conditions prevailing in Kashmir. In the first place, there has been a war going on within the limits of Jammu and Kashmir state. Part of the state is still in the hands of enemies, and in the second place, the government of India have committed themselves to the people of Jammu and Kashmir. In certain respects, they have committed themselves to the position that an opportunity will be given to the people of state to decide for themselves the nature of their constitution. So, what are the lessons from the text of Article 370? Mr. Iyengar had said in the Constituent Assembly that Article 370 is labelled a temporary provision in order to keep the door open for the day when the state of Jammu and Kashmir would merge with India and fully accept the Constitution of India. Today, a number of provisions of the Constitution of India stand extended in the state of Jammu and Kashmir. Important among these are Article 356, which deals with the imposition of presidential rule in the state and the jurisdictions of the Supreme Court, the Election Commission, and the controller of Auditor General. There is, however, a vast area that still remains under the exclusive jurisdiction of the state government. The Indian Penal Code 1860, the Prevention of Corruption Act 1988, the Religious Institutions Act 1988, and the Delhi Special Police Establishment Act 1946 are some crucial union laws that are not at all applicable to state. The Protection of Human Rights Act 1993, the Commissions of Inquiry Act 1952, the Unlawful Activities Act 1967, and the Representation of the People Act 1951 are only partly applicable. Can Article 370 be amended under the provisions of Constitution? The answer is no. Article 360, which contains the provisions governing the amendment of the Constitution, applies to all the other states of India except Kashmir. In relation to Kashmir, a proviso has been added to Article 360 by Constitution Order 1954, which says that no constitutional amendment shall have effect in relation to the state of Jammu and Kashmir unless applied by an order of the President of India. Under Article 370, Clause 3 of the Article 370 states that the President can issue a notification to cease the operation of Article 370 or to restrict it only on the recommendations of the Constituent Assembly of the state. Thus, any modification or deletion of the article requires the recommendation of state's Constituent Assembly. An improvable condition gives that the Constituent Assembly of the Jammu and Kashmir was dissolved in November 1957. A solution that has been suggested to this obstacle is an amendment of Constitution of India to remove the requirement that the recommendation of the Constituent Assembly is necessary to remove the article, but even such an amendment under Article 368 requires issuance of a presidential order under Article 370, which in turn will require the state government's concurrence by the President under Clause 1D of the current provision. The consequence of repeal. Given that Article 370 represents, Jammu and Kashmir's unique relationship with India, a probable consequence of its repeal would be the undermining of the position of the state in relation to Jammu. Article 1, which lists the territories of India, is applicable in relation to the state of Jammu and Kashmir only through Article 370, and that therefore the extinction of Article 370 would mean that the exclusion of Jammu and Kashmir from the constitutionally listed territories of the Union of India. If, as he says, the application of Article 1 to Jammu and Kashmir is subservient to Article 370, the abrogation of Article 370 would sever the constitutional link between India and Jammu and Kashmir, and the Indian Constitution will automatically cease to be applicable to Jammu and Kashmir. As a former Chief Justice of Jammu and Kashmir High Court, B.A. Khan, argued last year, if Article 370 is abrogated, then technically and legally, the foundation of Jammu and Kashmir's accession to India would cease to exist. So, what is the conclusion? Article 370 protects and grants special status to the sovereignty of the state, giving power to make a separate set of laws to be applied for its governance. And Article 35A protects the rights of people with respect to employment, property, and aids by the state government not incorporated in the Constitution of India. Thank you for watching this video. Thank you very much.